So thank you everyone for joining us today. I'm extremely pleased and excited to have as our guest today, Laurie Sage from Weirfolds to introduce Will and Estates, Getting Started, and to answer the questions our guests have submitted ahead of time. My name is Tim Hawley, and I'm part of the team here at JCIC Asset Management that supports the client experience, along with working with endowments and foundations. I'll be the host and moderator for today's call, and I think what I'm most looking forward to today is introducing folks to Will and Estates and maybe finding a starting point for their journey. Often this area can seem overwhelming, and it's wonderful and great to have professionals like Laurie with us to help simplify the concepts and act as our guide to complement the financial plans that we perform with our clients. But before we get started, I just want to let everyone know this call is in listen mode only. We will send this call out afterwards if you want to watch it again, or if you want to forward it or share it with some of your friends and family. If you do have questions left unanswered at the end of this webinar, you can absolutely reach out to myself or Laurie, and we would be thrilled and happy to assist you. Laurie will also be, or I'll probably be entering Laurie's contact information in the chat window so you have it. And with that, we have a lot to get through, and it's going to go by really quick. So with that, it's my absolute immense pleasure to introduce Laurie. She's an associate at Weirfolds, where she advises clients on estate planning and tax planning related to will and domestic trusts, as well as a plethora of other estate and power attorney related situations. So Laurie, welcome to today's JCIC Speaker Series webinar.
Thank you very much, and thank you for having me. I'm very happy to be here. So as Tim mentioned, my name is Laurie Sage, and I do practice in estates here at Weirfolds. And estates and trusts and estate administration, that's all I've been doing the entirety of my legal career. So here I am to talk to you a little bit about that. Specifically, what I'm here to talk to you about is estate planning, and that's something that I do day in and day out. Before I get started, I do have to remind you that the information that I will share with you today is simply that. It's information. It's not legal advice, but certainly, in conversation with your trusted estate advisors, you can get some more specific answers. But for now, this is just a starting point, a broad overview of some very important topics. So now to get started. When we talk about estate planning, we're referring to the process of preparing a will and powers of attorney. I often refer to it in the general term or the broader term of estate planning, as opposed to simply just wills and powers of attorney, because the process is so much more than talking about the document that is prepared at the end of the day that the client signs. As you'll learn in the course of the next hour, when we're talking about estate planning, we're concerned with a lot of things. We're concerned with tax planning, including income tax, estate administration tax. We're concerned with planning for beneficiaries, whether those be adult beneficiaries, minor beneficiaries, or beneficiaries with disabilities. And not only that, but we're also concerned with planning and talking about incapacity. So there's a lot that goes into this conversation. So before I dive into why it's important to have a will and to have these conversations, I want to just briefly talk about what happens if someone in Ontario passes away without a will. So my job is to help clients finalize their estate planning, oftentimes in the form of a will. There are other estate planning tools, but for the purposes of our conversation today, I will focus only on wills and powers of attorney. But as I said, it's also important to talk about why or what happens if you don't have a will. The latest statistic that I've heard is that about 50% of Canadians have wills. So the other half of us don't have wills. And I think it's important to talk about why that could be a problem. So generally speaking, when somebody dies without a will, their estate is distributed in accordance with provincial legislation. In Ontario, that legislation is called the Succession Law Reform Act. Generally speaking, the scheme that's set out in the Act is quite arbitrary and inflexible. So because it is predetermined, it has the potential to benefit the wrong people at the wrong time. So for example, most people are surprised to learn that common law spouses are not treated the same as married spouses and are excluded from the distribution of an estate in some cases when somebody dies without a will. It's also the case that when someone dies without a will, the administration of the estate is more costly and time-consuming, even if the affairs of that individual and the family situation of that individual are relatively uncomplicated. So when you're preparing a will, or if you're considering whether to have one, what are some of the issues that are important to consider? Preparing a will not only allows you to ensure that your loved ones are looked after regardless of relationship, as I mentioned, married or common law, but it also helps avoid or address certain important issues. So these are some of the things that we talk about with our clients when we're talking about their estate plan. So what happens if someone is separated but not divorced? There's been a recent change in the law to bridge the gap between separated and divorced spouses' entitlements on the death of a spouse. But the change is very recent, and there's strict criteria that have to be met in order to ensure that a separated spouse does benefit from a deceased person's estate. Consider also, what if one is estranged from a parent, a child, or a sibling? What if certain family members have more financial means than others? Who is going to administer the estate? And does this person have the requisite age, health, and skill set to do it? What if there are minor children or grandchildren? What if one of the beneficiaries of the estate is receiving government benefits or is a beneficiary with a disability? These are all things that we have to consider when preparing a will and when we're discussing an individual's estate plan. So why do you need a will, in addition to, of course, discussing some of the issues that I just went over? There are many reasons why a will is important. In general, having a will makes the administration of the estate simpler and less expensive. And put simply, by having a will, you're making the lives of others and your family members, your loved ones, much easier on death. So for example, a will allows you to choose the beneficiaries of your estate. Recall that as I just mentioned, by not having a will, the list of beneficiaries is already set. It's predetermined. A will also allows you to maintain control over your assets. So it can dictate when certain assets are to be distributed and how. In certain situations, for example, in the case of a family cottage, if the desire is for the cottage to stay in the family, a will can spell out how this is to be done, who deals with the taxes, and so on. So it can be a place where you can put instructions and a comprehensive plan for those particular wishes if of an important asset like the family cottage. A will also allows you to engage with and to consider tax and tax savings, both income tax and estate administration tax. Very importantly, a will lets you have a say in who administers the estate. So choosing the trustees and the executors of your estate requires careful thought, and the choice may not always be obvious. Executors are responsible for a lot. So when you're preparing a will, or when you're considering preparing a will, it's important to understand that the individuals you're naming as the executors have a very significant job. And the job entails, from something as simple as arranging the funeral, to reviewing the will, determining the assets of the estate, gathering in the assets of the estate, paying your debts, liabilities, taxes, notifying and keeping in touch with beneficiaries, applying for probate, distributing the assets, filing tax returns, and so on. The list is quite comprehensive, so careful thought needs to be had as to who is best suited to take on this job. A will can be amended and revoked in a variety of ways. So once you have something in place, it's not set in stone, and it can be changed easily or revised easily. In Ontario, we do have a law that allows people to prepare wills entirely in their own handwriting, and that's called a holograph will. However, as you will see, estate planning and will drafting has a lot of complicated nuances to it. And it's always best to engage in that process with a professional to make sure that all the issues and considerations are looked after. Once a will is in place, as I mentioned, it can be changed or revoked. You can do that by preparing a new will, by tearing up the will that you currently have, throwing it in the shredder, or a will can be changed by certain life circumstances. So specifically as it relates to family circumstances like separation or divorce, that can affect what your current will says. So far we've covered the benefits of having a will. Now let's talk about what we need to think about when preparing that particular will. So in Ontario, we have a lot of freedom when it comes to deciding who benefits from our estates. So generally, a person can do whatever they want with their assets on death. However, some restrictions do exist. And really, the restrictions are based on which beneficiaries cannot be left out. And secondary to that, restrictions do exist with respect to how title to an asset is held. Provincial laws attempt to protect certain individuals and their rights to financial support on death. So although we do have quite a lot of testamentary freedom in Ontario, there are some restrictions and limitations. Specifically, provincial laws attempt to protect spouses, minor children, financially dependent adults, including children or parents. Most often, if these individuals are not looked after in the distribution of someone's estate, they have to bring a court application in order to make a claim for support. So as such, who could be a dependent of your estate is a significant consideration when preparing your will in order to ensure that the provincial legislation doesn't step in and potentially change the intended beneficiaries of your estate because they're deemed to be dependents. Another issue to consider when preparing a will is how a person holds title to their property and to their assets. Not all property that someone owns will fall into the estate to be captured by the will. So there's a list of assets that tend to operate differently on death, and that affects how or what beneficiaries get which particular assets. So for example, assets that may not be captured by a will include jointly held property. In most situations, property that someone owns jointly with another person or other people automatically passes to the surviving joint owners on the death of an owner. So for example, people who have an interest in real estate that they own jointly with someone else, and they wish to pass on that interest in the real estate to the beneficiaries of their estate. If they hold the property jointly and they're the first to pass away, well, unfortunately, the asset is not captured by the will, but it automatically goes to the surviving joint owner. The second set of assets which may not fall into the estate include properties or assets that have beneficiaries named. So this typically includes registered retirement savings plans, registered retirement income funds, tax-free savings accounts, and life insurance. If a beneficiary is named on these proceeds, the funds will go directly to that beneficiary and will not be captured by the will. So it's always important to understand the setup of those products. Third category of assets that may not or are not captured by the will are assets that are governed by or whose distribution is set out by another agreement. And some common examples of this include marriage contracts, separation agreements, and shareholders agreements. To the extent that those documents speak to the terms of what happens on death, that document will actually override what is set out in the will. So it's very important that those two documents work together and don't contradict each other. The last common examples of assets that may not fall into the estate include interest or income from a trust. So because these assets are held in a trust, they do not belong to the individual who might receive payment and may be a beneficiary of the trust. So those are common examples of assets that may fall outside of the estate and outside of the will. Generally speaking, when we're talking about assets that are captured by your will, we're looking at real property, bank accounts, investments, and personal belongings, and really any and all assets that one owns in their name alone. So now that we know that certain assets are not captured by the will, let's talk about those that can be distributed pursuant to a will. In a will, there's only two ways to distribute your estate, so not a lot of options there. The first is a distribution that is absolute. So this means no strings attached, and the beneficiary simply gets the inheritance, whether it be in the form of property or cash or anything that the will might set out. The second way that an asset of the estate can be distributed to structure a distribution of the estate is by creating a trust in the will. This means that the distribution to the beneficiary is delayed or has some conditions. And a common example of this is a distribution is delayed until the beneficiary reaches a certain age. In the meantime, it also means that someone has to be responsible for maintaining that asset until that future event happens. Delaying a distribution by creating a trust may be appropriate in many scenarios, and this is a conversation that we have with clients very often. So first, we typically talk about delaying a distribution and creating a trust for beneficiaries with disabilities. Often, creating a trust for such beneficiaries ensures that someone handles the beneficiary's inheritance, but it also ensures that the beneficiary is still eligible for government benefits. And in Ontario, we're mostly concerned with maintaining entitlement to ODSP, the Ontario Disability Support Program. A trust may be appropriate in family scenarios or circumstances where we have a second or third relationship, or sometimes we refer to that as blended families. So in a scenario where someone wants their second or third spouse to benefit from the estate, but still ensure that perhaps children or other beneficiaries are looked after, a trust can be set up to account and to look after both sets of individuals or both sets of beneficiaries. The third scenario in which a trust would be useful and common in a will is when we're talking about minor beneficiaries. As I mentioned, this is fairly common, and we just want to ensure that the minor beneficiary receives the inheritance when they reach a certain age. Typically, that's the minimum of the age of majority, but oftentimes it means beyond the age of majority. Trusts can also protect people from creditors and can be used to protect the inheritance of a spendthrift beneficiary. And lastly, trusts and wills can also be helpful when it comes to U.S. estate tax planning, which I will briefly touch on. So speaking of tax, as I mentioned, when we meet with clients and we discuss their estate plan, we're constantly concerned and focused on discussing income tax as well as estate administration tax. So in Canada, we do not tax on a person's wealth on their death. However, when a person dies, they are deemed to have disposed of their assets immediately prior to their death. This is a deemed disposition of assets, which typically brings in accrued capital gains into income. So there are a few ways in which we can talk about deferring or reducing the income tax payable on someone's passing. And some broad examples of this include transfers to a spouse or to a qualifying spousal trust, talking about the tax or the principal residence exemption, and charitable giving. Many Canadians, when they're doing their estate plan, also have to consider U.S. estate tax on death. And U.S. estate tax can come into play in a variety of situations. So the most common are when a Canadian owns U.S. situs assets, so assets that are located in the U.S., whether it be, a property in Florida or Arizona or wherever it may be. U.S. estate tax needs to also be considered when both spouses are citizens of the U.S. Unlike some jurisdictions, or most jurisdictions rather, the U.S. taxes on citizenship and not residency. It's also relevant when one spouse is a U.S. person, and also when neither spouse is a U.S. person, but at least one of their children or a beneficiary of the estate is a U.S. citizen. So all of these scenarios are relevant in the discussion of estate planning for those individuals, and typically have to do or are governed by the size of the estate. So it's important that this be a key topic of conversation with your estate planning advisors to make sure that there is limited, or if there is exposure to U.S. estate tax, that's properly handled and you get the proper advice on that. So far we have covered some major income tax considerations when it comes to estate planning. And right now I want to shift gears and focus on another tax that a lot of people tend to worry a lot about, and that is probate fees, or also referred to as probate tax, but in Ontario properly referred to as estate administration tax. And this conversation about estate administration tax, I find that it causes a lot of stress for clients, and it's a big topic of conversation in our meetings. So before I dive into the details of the tax, let's take a step back and talk about probate as a process. Well, what is probate? Probate is a judicial evidence of the authority of the executors named in the will. It's important to note that an executor's role or authority does not derive from probate, but it actually does stem from the will itself. So probate is not technically a legal requirement, but it is a requirement in specific situations. Most common example is when there is no will. So if someone dies without a will, it's almost a guarantee that they're going to have their estate or their family is going to have to go through the probate process. On the flip side, if there is a will, there's lots of opportunity to avoid probate. Probate is also a necessity when there is a will, but no estate trustee is alive or willing to act. We also need probate anytime that it's set out by particular legislation, and most often, if probate is required by a third party, typically a financial institution, in order to allow them to transfer title from the deceased to the executors of the estate. So, why is probate an issue? In addition to going through the court application process to apply for probate, probate is an issue because of the associated tax, the estate administration tax that I mentioned earlier. In Ontario, which is known to be one of the jurisdictions in Canada that's on the higher end of the probate tax, probate fees are determined on the gross value of the estate as of the date of death. And in a more specific way, there are no probate fees payable on the first $50,000 of an estate. So there's a freebie there. But the tax is applied, calculated as $15 per $1,000 over that $50,000 threshold. And the only deductions that are allowed on the calculation of the fair market value of the estate on which the tax calculation takes place are encumbrances, typically mortgages, on real property. Now, because that calculation is kind of hard to wrap your head around and hard to articulate clearly all the time, we tend to simplify the probate tax calculation and say that it's about 1.5% of the fair market value of the estate. So now that we've talked about this probate tax, naturally we want to consider some ways in which we can defer or minimize the tax, which is very proper estate planning tools. So a lot of my discussions with clients are centered around ways in which we can do that, in which we can defer it or in which we can minimize probate tax. And one common way to do that is to hold property jointly. Now, this is a very common estate planning tool that works well as between spouses. However, when we're talking about holding property jointly, whether it be real estate or accounts with other people, it does make things a little bit more complicated. So although joint ownership is a good probate planning tool, there are certain disadvantages to simply relying on it for that purpose. So in addition to the uncertainty on death that can take place on the death of a joint owner, joint ownership could create problems while both joint owners are alive. And so some of the examples of these problems include that joint owners will have equal interests in and equal rights in the property. Therefore, if one owner wants to sell the property, they'll need the consent of all the joint owners. Secondly, on the death of a first owner, the asset does not pass through the estate. Now, this goes to my point earlier about how joint ownership typically functions, and it typically goes to the surviving joint owner. But when there are multiple people involved or different parties, this can create or this can result in a lack of clarity as to what the intention is with the property. Another issue is that any joint owner could sever the joint tenancy and own his or her share as a tenant in common and essentially potentially force a sale of the property. Joint ownership can be problematic when the owners could potentially have debt problems and creditors could force a sale of the property and take a portion of the proceeds. So all that to say is that although joint ownership could reduce estate administration tax, sometimes the complications that result when it's not done properly significantly outweigh the benefits of strictly focusing on saving the tax. Another way that we focus on reducing estate administration tax is by having named beneficiaries on accounts. So recall that I mentioned that certain assets flow outside of the estate, and namely including RSPs, TFSAs, and life insurance. If beneficiaries are named on these types of accounts, the beneficiaries get the proceeds directly outside of the will and outside of the estate. Therefore, what this means is that the value of those proceeds is not included in the fair market value calculation of the deceased person at the date of death, which means that the estate administration tax is not calculated on that additional amount. And as I'm sure many of you are aware, a beneficiary designation can be made directly with the institution which holds the account, but they can also be made in the will. In the will, it allows us to provide a little bit more structure, primarily in the form of a trust for those accounts and the proceeds that flow from those accounts. And even though I said that these accounts or these proceeds flow outside of the estate, outside of the will, even though they're in the will, it does not mean that they're counted for the purposes of probate. So when it comes to beneficiary designations, I always encourage clients to speak directly with their advisor on that point and make sure that the intentions, the designations, and so on are done consistent with their wishes as to who should receive the proceeds, but also with an eye to ensuring that to the extent that estate administration tax can be saved, that we look to do that as well. And the third and most common way in which we seek to reduce, eliminate, or defer probate fees are by having multiple wills. So in Ontario, individuals are allowed to have 2 or more wills that operate at the same time. Most often, it's enough to have 2 wills, and typically we refer to them as the primary will, the secondary will, the public will, the private will, or the probate will, and the non-probate will. So they do have a few different names. But essentially, the purpose of having multiple wills is to allow us to structure the assets and the estate such that the assets that do not require probate, that typically do not require probate, can be carved out and can be referred to in the secondary will. And then the assets that do require probate can operate separately in their own will. And by carving out the assets and by having multiple wills, the idea is that you're saving estate administration tax, you're saving that 1.5% on the value of the assets that are found or that flow through the secondary will, the business will, the non-probate will, as they're commonly known. So multiple will planning as an estate planning tool is a very common tool that we use for clients. And most often we find that it's helpful or most commonly used for clients who have private company shareholdings. So that's typically a few of the key indicators where multiple wills might be suitable. Right, so up until now, we've talked about planning for death. However, another important aspect of estate planning is planning for incapacity. And this is done through preparing powers of attorney. In Ontario, there are 2 types of powers of attorney that we can have. The first is a power of attorney for personal care, appointing people to make healthcare decisions on your behalf if you're unable to make those decisions for yourself. And secondly, a power of attorney for property, appointing people to make financial and property decisions on your behalf. Generally, we focus on these 2, and I'll start by talking about the continuing power of attorney for property. Unless the document is restricted to dealing with specific assets, the attorney for property can do anything you can do with your property or finances, except they cannot make or they cannot change your will. So they have a lot of authority and a lot of power when it comes to dealing with all kinds of aspects of decision-making as it relates to property and finances. A key consideration when preparing a power of attorney document is talking about and thinking about when it comes into effect. Will it come into effect as soon as it's signed, or will it come into effect when a person becomes incapable? Most powers of attorney are effective as soon as they're signed, or most powers of attorney for property are effective as soon as they're signed. And really, this is to avoid what we sometimes refer to as the gray area of future incapacity, and to avoid having to go through any formal process or evaluation, including a capacity assessment, to prove that that individual is not capable of managing their property or finances. So it's effective upon signing, essentially with an eye to having the attorney step in a more organic way to start managing that person's finances. And this document is very important because if someone doesn't have the capacity to manage their financial affairs, there's no person who's automatically next in line or entitled to make those decisions for that individual, not even a spouse. So what happens in those situations is that a family member or a friend needs to apply to the court and become the guardian of property of that person, which can be a long and expensive and intrusive process. So to the extent that that can be avoided, it can be done by having this document in place. Other issues to be considered when you're thinking about who you're going to appoint as your attorney are whether or not that person is a US resident or a US citizen, as the appointment of that individual in the documents could potentially trigger certain reporting obligations in the United States. So we often talk about that with clients. The last thing to consider when you're preparing these documents or this document is whether a separate power of attorney should be prepared to deal with assets in a different jurisdiction. So for many Canadians who spent time in the US over the winter months or elsewhere, it's important to consider whether preparing multiple powers of attorney that work in the jurisdiction where they spend some significant time is worth doing to allow them to make sure that assets in those jurisdictions are looked after if they don't have capacity. However, it's also important that this type of planning and these type of documents be carefully prepared because we want them to ensure that they work across the different jurisdictions and not revoke or potentially contradict or undo what happens in Ontario versus, let's say, what happens in Florida. And lastly, powers of attorney for personal care. So the last important document that we typically prepare as part of an estate planning package is the power of attorney for personal care. This document deals with appointing individuals to manage your healthcare, welfare, nutrition, shelter, consent to medical treatment, and end-of-life decisions. Basically, it covers every aspect of one's personal well-being. And by preparing this document, you're appointing the person to make healthcare decisions for you, but only if you are incapable of making those decisions yourself. If you have capacity to make those decisions, then the document is not effective. Now, contrary to the power of attorney for property, if you do not have this document naming individuals to make these decisions for you, there is a hierarchy of individuals listed under legislation who can step in and act in this role. However, the list and the order is set out by law, so it's very strict and very rigid. And who you would choose versus who's listed in the legislation may not necessarily be the same people. So as a result, it's important to have this document as opposed to relying on a predetermined list of people, which may not reflect your wishes. In addition, this document also lets you set out any specific wishes with respect to your treatment or healthcare. So it can be quite specific to your wants and needs in this regard. However, what the document does not yet allow us to do is have the attorney for personal care consent to medical assistance in dying. So as of recently, Canada has laws that enable people to obtain medical assistance in dying. However, they have to meet certain criteria and they have to have capacity to consent to the process. So that means that as of now, the current state of the law does not allow an attorney for personal care to consent to medical assistance in dying on your behalf. Right. So now that you know the benefits of having your planning documents in place, and I know that everyone will be sure to do so after this presentation, it's also a good idea to keep in mind when these documents might require an update. Although this is not an exhaustive list and does not take into account people's unique scenarios and life and family circumstances, generally, these are some events or times where you might want to consider turning your mind to your estate plan. So generally speaking, changes in marital status. That's a big one. Marriage, separation, divorce. Births, adoptions, deaths in the family, that's also another time to consider. It's also important to turn your mind to your estate plan when there is a change in assets. So whether you come into some assets or whether you restructure them, but also importantly, if you obtain property or assets in other jurisdictions. It's important to think about updating your plan when beneficiaries leave the province, they get married, they get divorced, or if they might experience a disability. Also important when an executor dies, becomes incapable, gets to an advanced age, or you acquire assets that require a different set of skills or expertise to be dealt with, and considering whether that executor is suitable to handle the new or the more complicated assets of the estate. Changes in law, that's sometimes a good idea if there are significant changes, to think about how that might affect your estate planning. And more simply, changing your mind. So as I mentioned, you can update your estate plan at any time. It's the important thing is getting started, having a plan in place that best reflects your current life circumstances, but also appreciating that those life circumstances will change. And so likely your mind will change as that happens. So that does bring me to the end of my discussion today. I appreciate that I have provided what probably feels like an avalanche of information as it relates to estate planning. However, what I hope that you take away from today is the importance of turning your mind to having wills and powers of attorney, and also doing that with the help of trusted professionals to guide you along the way, because these are big decisions, and the more help you can get, the easier it will be. So thank you very, very much for having me here this afternoon.
Yeah, thanks so much, Lori. We're just going to get to some of the questions that folks submitted
Absolutely.
before the seminar, and I'm really looking forward to your answers. But I just wanted to reiterate, you took a really heavy and complex subject that maybe some of us shy away from talking about, and really made it into digestible pieces and very simple to understand. So I absolutely echo that's the value of working with an advisory team and helping you through some of these larger parts of life as it
I
pertains to
appreciate that.
all facets of your journey and your financial journey and onward. Um, so with the last few questions, and great questions. So the first one is our principal residence subject to capital gains for our children to pay?
So generally speaking, assuming it meets the criteria of a principal residence, normally the capital gains would not be payable on that, or there is a capital gains savings as a result of the specific principal residence exemption found in the Income Tax Act. So broad level, yes, but of course nuances could change that answer.
Yeah, yeah, and I appreciate you giving general answers. Some of these questions have been fairly specific. So to echo what you said on the front end, not to be construed as advice, but really a starting point with some of these questions.
Yes.
How to transfer corporations from generation to generation?
So that is a big one. Certainly, it's a major consideration for clients who are turning their mind to estate planning. Whether that transfer is to occur or to start while the main business owner is alive, or whether that's to take place on the death of that individual. And frankly, it's hard to give a broad answer to that, because a lot of those decisions are tax driven, in addition to to ensuring that the right people and the right beneficiaries are kept in mind, but certainly something that we would talk about in detail and get the conversation going.
Yeah, it's interesting if you take that question and you look at it from a legal perspective and maybe a tax planning, financial planning perspective. If you try to answer those independently, it becomes a little overwhelming and tougher to answer. But if you seek, appropriate legal advice, and you work with, we have Godfrey, you and our staff here as a planner, and very well decorated, it becomes a lot easier, right, to plan and to start answering some of those questions. And again, I think that's where tremendous value is derived. No,
Absolutely.
no, thanks for that answer.
Absolutely.
Would appreciate comments on tax efficient ways to structure a will for a single senior.
Yeah, absolutely. A lot of what I covered already is focused on doing exactly that. So first of all, a will, great starting place, but also looking at the individual assets that this individual owns. So can we do some tax savings with some registered investments, beneficiary designations, and so on. There's a lot of opportunity for planning tax deferral, tax savings, depending on who the intended beneficiaries are. So a lot of what I covered would certainly fall into those tips that I would give that person.
Excellent, thank you. A couple of quick ones here. Once the will is signed, how often should it be reviewed? And I know you mentioned some life events there and whatnot. Is in my first perception was, aside from those major events, like on an annual basis, and maybe that's just a common misperception. What's your thoughts on that?
So aside from any of those big changes that I talked about, we tell clients to think about this every 3 to 5 years, just as a ballpark. But if there is something that has changed or you change your mind, certainly at any point in time, there's no right or wrong answer. But absent that, yeah, 3 to 5 years, I would say.
Okay, wonderful. And how important are this is actually interesting. How important are beneficiaries' pre-will regarding all your assets?
Free will.
Yeah, so
Um,
so when should you start thinking about, I guess, who you want as a beneficiary, and maybe you forget to put that part in there.
so, I mean, I think if this is getting at sort of who we're going to name or
Yeah,
what point in time, um, the simple answer, and when people ask me, when does somebody need a will? Is there a time when you don't? And I would say, if you have even one single bank account, you should probably have a will, let alone other assets. And it can be difficult, especially given different life circumstances. But the beauty of having a will is that there's a lot of flexibility. So it really allows you to think about, all right, if something did happen to me, what would I want to do with the hard work that I've put into acquiring what I've put into. So yeah, it's not an easy answer because it's very fact specific and very dependent on that person's situation, but always good to think about who would benefit from your estate if something were to happen.
great, great. And the last question. So this is maybe right in my wheelhouse here. What resources are available to inexperienced executors? We often hear about people going online and Googling, what do I do as an executor? And I think we've seen the value of kind of marrying the legal with the financial advice. Are there any maybe resources that you can offer or suggest?
Um, I would say the best resources, and I'm not just saying this, I truly believe it, are professionals that have experience in this area, whether that be investment professionals, whether that be tax professionals, whether that be legal professionals. It's almost an expectation that, and I wouldn't say almost, I would say it is an expectation that the executor gets the absolute best advice so that they can take the best course of action to maximize the estate, to administer it efficiently and quickly. And that guidance and those resources can be found in the professionals that have different roles, very unique and specific roles along the way. You know, absent that, I mean, we try our best to, of course, help clients on the legal side of things, to the extent that maybe they just want a little bit of a push as opposed to pretty involved help along the way. We would have a simple guide and highlight what it is that they're responsible for. I know that on the Ontario Ministry or the Ontario Ministry websites, some ministry websites do have particular helpful information about what happens if someone dies and you're named as an executor. That's sort of very high level information. So a lot of resources and details are out there on the internet. It would probably be endless, but if I'm being honest in what I think the best thing to do is to get that professional help.
Excellent. And with that, thanks everyone for staying with us. It went by really quick for myself. So, thank you again, Lori. It was awesome having you. I got a lot of great information from that. Gave
My
some
pleasure.
great deeper insights into navigating the mystery of wills in the States, and a great starting point. I think that's the main point here. Again, if anyone has further questions, please reach out to myself or Lori. Her details are in the chat window there directly. Her coordinates are there, and again, I'd like to thank everyone for submitting your questions prior to the call and allowing us to get to those, and for taking time to join us today. Please watch out for our next speaker series coming up next month, and we'll be sending that invitation out in the coming weeks. If you have any other topics that you'd like to hear more about, and I think we've got a couple more topics from our discussion today, reach out to me directly, and because what's important to you is what's important to us, and we want to cover some of those items. And please feel free. This is valuable resources. We want to make it available to your friends and your family members, and so please share where you think there might be a value to those folks. And again, thank you for joining us, taking time out of your day, and have a wonderful day. And we'll see you all soon.
Thank you very much.
Thank you.